organizers for inviting us. I think it's a very opportune time to reflect on all the challenges that I think in the morning some people already are alluding to. Some of the challenges that, as the Center for Child Law, receive some complaints from some of you, engage with the department, trying to find solutions. But at the heart of it for us is what I've been asked to do today, which is talk a bit about the children who are at the center of all this. Because at the end of the day, there's a child there that needs to go through a process to be adopted, to have a family with long-lasting solutions, and people will take care of them. Before, I promise to keep it short, but there's some things that I want you to say that Dr. Mabe has already mentioned, so I'll manage my time. But I want to tell a quick story. So when I started at the Center for Child Law in 2007, it was the year that the AD versus DW and others case was on the way to the Constitutional Court. Many of you might be familiar with it. I think the department will always remember it. And I want to quickly mention it. It was an inter-country adoption case, but it was a very important case because it had to do with processes that were not in line with the law. Yes, there were problems with the law in that the Children's Act had not come into operation. We still had the Child Care Act. Yes, there were problems with how non-South Africans could adopt, and maybe the process was slightly slower. But I think there was a comment earlier in the front that we need to reflect about what are the reasons for some of those processes. And you know, I'm going to try and give a very balanced kind of a presentation because at the end we're serving the children, right? And in that case, I got to the center and everybody's working on this. The center had already been involved in the High Court and we're going to the Constitutional Court. The National Department was not even a party in the case, and people were challenging the process of the National Department. They were trying to use guardianship orders to take children out of the country. A lot of implications in relation to the immigration status of the children when they get there. We don't have record of where the children have gone, and all sorts of things were coming up. And our center went into the case to say, hang on, the department might have faults with their process, but there's a process and there's a reason for it. And it went all the way to the Constitutional Court, who said that they agree with the department that even though it was now in the best interest of that child to be adopted by those particular people, the process was in the children's court, and they must go and do that, and that matter must be finalized within 30 days, which was done. And some of the people will be aware that after that, the child went to the US with that couple, but that adoption fell through. The Constitutional Court was notified that now the child is now with other people because those people did not want the child. Now imagine if there was no process and there was no record, there was no, if that child ever one day came to South Africa wanting to find out who are they, where they're from, and all those kind of things, who would answer to them? Because they would have been, just gone on an order of guardianship. So I point this out to just remind us that there's a reason why there are processes. Processes are not always perfect. And what the Constitutional Court said in that case, and I'll keep coming back to it, is that your process must also not be unduly rigid. It must not frustrate the best interest of the child at the end of the day. But there are reasons why we have processes. So I want to say that as we deliberate, as we think, as we try to help the department find solutions, and as we try and take on the magistrates, I'm a lawyer, but sure, the magistrates are giving everybody a headache, eh? I hope they're not here. So we need to then work together to find solutions that will really serve the children. Equally, Dr. Mabe, Home Affairs, I want answers as to why they've decided on a policy position for you guys about how you deal with children who are in the protection system. They asked is to, at the end of the system, register those children who have already been adopted. I want us to engage on that and challenge them to answer that. Statelessness, you mentioned it. That means that that child now is left under a dustbin somewhere. You pick up the child is in the care and protection system. You can't get the child adopted because there is a presumption in the Birth and Death Restitution Act that adopted children are now all, abandoned children are now all foreigners. So we bring up children in the care and protection system who can never get a birth certificate. When they become 18, they have been here all their life. What are they supposed to do? We're planning to deport them all back to where? So we need to think about this. It's not a simple thing of the department, and the Department of Home Affairs, with all due respect, they're doing this to the Department of Social Development, even with unaccompanied migrant children, who've been in the CYCCs for years now. And when they turn 18, we have to put our hands up in the air and say, what now? We've raised them since they were 6, we've raised them since they were 12. What are we supposed to tell them now? It cannot be that we have that, and we have obligations to the African Committee on the Rights and Welfare of the Child, we have obligations to the CRC committee that we've undertaken to comply with, and now their views on managing migration and managing those issues is being imposed in a way that does not take into account those policies. I really think that's something that they should be challenged on, and it should be a concerted effort. You know, we're always ready to go to court when push comes to shove, but it concerns me because we're already seeing the unaccompanied minors who've now become adults. Many of you have made, you know, pleas for assistance in those. Now we'll have all these babies that we can't do anything about, and we're supposed to assume that babies are all foreigners. It cannot be. It really needs us to pause for a bit of reflection. Anyway, back to the business of what I've been asked to do. Oh, can I just go home with that? Okay, so I wanted to go back because you know, this fees must fall and everything, and everybody's trying to track where we started with things and decolonization, when did we get colonized, and when. In relation to adoption, I wanted to find out when first did South Africa sort of recognize and regulate adoption, and I found that it was in 1923. Sure, the landscape was different. Maybe there was a smaller number of children that were getting adopted, and maybe it was, you know, family arrangements kind of a thing. But this was the law that came into operation, and the law was based on a law from New Zealand. But what I wanted to quickly point out that relates to children is that even as far back as then, South Africa had included provisions that really emphasized how adoption could only be ordered if it was in the welfare and interest of a child. This, the New Zealand provisions did not have. And moreover, there was also a process where there could be a guardian appointed to consent to that child's adoption, and to also enable the court to maybe not immediately grant adoption, but wait for a period of 2 years to see how things are developing before they grant an adoption. Now, you know, I mean, this is just briefly just a historic thing, but I really think that it sort of shows that what we have today in our law comes from that. Yes, we had the Child Care Act before the Children's Act, but even as far back as 1923, there was a recognition of the welfare and interest of the child, already as far back as that. And also the fact that children who are 10 years and older had to consent to their own adoptions. So I think most of us know what the purpose of adoption is, and Section 229 of the Act captures that. It really, again, emphasizes that you have a child who needs a stable home that you need to provide for, and not the other way around where you have a family that you need to serve and fill their need. It should be the other way around. You know, and that's very important to remember, because some of the problems come in there, that some people are so eager to help people find children or get children that then the laws and the processes feel like a serious frustration. We really need to think about that. So adoption is also a device that's intended to imitate nature in respect of rearing a child and to provide a permanent, secure, healthy life for those willing or able parents. It aims to create family relationships for the child that are intended to last a lifetime. So again, central to this is the child. The issue of the unaccompanied migrant children, the abandoned babies and the foreign babies comes into the issue of adoptability. So who are the children that are adoptable? In terms of the Act, it's clear. It's a child who's an orphan, whose parents' whereabouts are not known and cannot be traced, a child who has been abused or deliberately neglected, a child who's in need of permanent alternative placement. And I want to make this point again. Nowhere in the law is there any distinction based on nationality, based on any kind of criteria like that. So when it's said to us that because the child, we know that the mom was from Lesotho, therefore the child cannot be adopted, I beg to ask the question, is the child adoptable in any other respects but for that fact? And where does that come from? Nowhere under the Home Affairs legislation is there such a provision as well. And we definitely don't have that under the Children's Act. So we need to think about this. I'm not saying that these are simple issues to resolve. I'm aware that there are also issues where the parents who are non-South Africans, illegal in the country, are trying to get their children adopted, and they don't just abandon them. They're working with some of the social workers. And there are issues about the fact that when they don't have ID numbers or identity books, how do you then record their consents and all those things? Yes, we need to engage on those and find ways of dealing with that. But one of the things that we need to think about is the fact that if you're now going to have a system where people are not able to safely hand over their children for adoption, then we'll have an increase in abandoned babies. And again, as I said, Home Affairs then says all abandoned babies are foreign babies. Then we sit with the same problem. So I think we need to reflect on that. And the courts. We know the magistrates have become difficult. We've had my former colleague, Karina Ritoy, who many of you know, had like 6 cases at the beginning of this year where 2 of them had to do with a child who's non-South African. Luckily, they've been resolved because the magistrates have allowed those adoptions. But now, sitting here today and hearing the fact that Home Affairs has sort of placed a moratorium on this, it worries me that there is such a moratorium. The idea of best interest, so we have it in our Children's Act, we have it in the Constitution, but I want to just quickly point out that under the CRC and the African Charter, which Professor Julia mentioned this morning, there's something quite interesting. There are provisions that relate to the rights of children. There are also best interest provisions. But when it comes to issues of adoption, both these treaties have actually a provision that state parties must recognize or permit the system of adoption that shall ensure that the best interest of the child shall be the paramount consideration. Both these treaties on all other issues, the standard is primary consideration. But for adoption, it's paramount consideration. So they're elevating the standard of best interest for a child who stands to be adopted, which then sets you a higher premium for how you then evaluate how that adoption will serve that child. And then in respect of adoption, they further say that the best interest should be strengthened. Oh, I've already touched on this. Let me just go to the next one. The UNCRC has, they have general comments, and there's a general comment on best interest. And the general comment states that the fact that due consideration of the child's basic interest in relation to adoption implies that children have access to the culture and language, if possible, of their country and family of origin, and an opportunity to access information about their biological family in accordance with the legal and professional regulations of the given country. So we've already touched on this, and in terms of inter-country adoption, it's an issue of subsidiarity, but I think that this also speaks to what one could call domestic subsidiarity in a way, which is that we need to try and see if a child is adoptable, whether they can be adopted by people who are closer to their culture, closer to their lifestyle, kind of a thing. But that should also not mean that you have processes that take long because people are trying to find things that are not there. And I'm supposed to give an example. We had a query in KwaZulu-Natal where one social worker was being given a runaround by the magistrate because now they want to find a grandmother who actually chased away the mother when the mother was pregnant with a child. And now, because of domestic subsidiarity, let me call it, keeping the child within the family, they want to now ask the grandmother to take the child in. So, I mean, the dynamics of that, already you can think. And this really requires us to think a bit hard about what does that mean? How far back do you go to try and find answers? And then you have a positive story that the department worked on where the child was about to be adopted internationally, but there was a family that was found in Mpumalanga, and recommendations were made that that family did not know that the child exists and they could adopt the child. And it went well and ended happily. So we need to try and do that. But what I want to say is that in relation to that, that goes to how we do and when we do things. So the steps that we take. That finding of an aunt, an uncle, or an extended family member that could take that child in and adopt the child before the child is made available for people outside and then eventually for inter-country adoption must happen at the beginning. It must be one of the things that we do right at the start, so that you don't face a magistrate who then later says that I hear there's a grandmother in somewhere and I go and do a report and I want the grandmother to come here and take the child and things like that. So we need to think like that. I always say that the steps matter when you do what and how, so that by the time you get to court, it shouldn't be a question of now getting stuck, because that only frustrates the progress of one person, and that's the child, because then the child stays either continues to stay in temporary safe care or in a child in youth care center. Now you have to go back and redo all those things. So we need to think about that. Also want to pause and remind us that what the court said in AD, which is also important, which is the fact that subsidiarity is very important, and in this context it had to do with the child being available for domestic adoption before going before being available for intercountry adoption. But the best interest, the paramount principle, is something that must be looked at an individual basis, and that the paramountcy principle is also the one that outweighs the subsidiarity. So the court, and that's what the court did in 80, the court said, look, yes, we hadn't made the child available for a domestic adoption, and there was a couple that could have been all good and well fitting. But now the child is bonded with these people, and her best interest requires us now to allow this adoption. Of course, as you know, that's one of the things that we struggle with, the issue of pre-matching and all that, and people forming relationships with children before court orders are given. And some of you are more familiar with the challenges that come with it than me. But these are things that we need to think about as we're working with adoptive parents and and children on a daily basis. Again, to emphasize, the court said that we need the laws, we need the processes, but they should not diminish the possibilities of looking at an individual child's specific circumstances. So again, it's the same. So I would say that the Department of Home Affairs says that all abandoned babies must be treated as foreigners, or cannot be registered, or cannot be adopted and registered. The adopted part, I don't know where they get the power to tell the Department of Social Development that. But nonetheless, that means that all children are then treated the same. There could be an abandoned baby whose father is South African, but the mom is a non-South African. Then how do you deal with it? Do you still call the child a foreigner? Or the other way around, because that's the nuances that we need to think about. You cannot, just use this blanket. And I think I need you to, when you have time, I know we work with the Children's Act primarily, but when you have time, just have a look at the Birth and Death Registration Act and the provisions thereof, and the challenges that they pose to your work. I know some of you are already familiar with it, some of you have tried to register babies and you tend away and all that. But really, that's where I think the Department of Social Development, we need to work together to address some of the issues with the Department of Home Affairs, because it's going to let us sit with the problems. I think I'm not going to talk much about this. The issue of RECAP has come out quite a lot. Again, I think the processes are necessary, but the processes must not frustrate the adoptions. They must facilitate. I think there's no way the Children's Act provisions on adoption were written to frustrate adoption. I don't want to believe that for a moment. They were meant to facilitate, and we need to really unpack how we can, what's working, what's not, what needs to be amended to have a better process, which process needs to be shortened, and how. And that's where our reflection should be. Saying, oh, it's not working, all of it, it's not going to help anyone. There are countries that even stopped adoptions because they don't have systems, or they don't want the children to go on inter-country adoption and all that. And I know we have a lot of orphan children. And again, here I pause to say that this morning I had the question about the issue about children who could be potentially adopted by the family members. And I know that's something that's not easy, and we need to research it a bit and find out. And the research of 2010 was mentioned. And one of the things that always comes up is the issue of people saying, well, I'm a grandmother, I don't want to now be the mother, kind of a thing. And those are people's realities, and we need to think about how do we address that? Is it really feasible to think that most of the children who are orphaned will be absorbed into the adoption system? If not, what will be in their best interest? The issues of the extended support, child support grants were mentioned by the colleague from Children's Institute, and those are very important options that may take pressure off the care protection system in a way. This is just to emphasize the issue of permanency and the fact that, I know some of you have also worked with mothers who change their minds. We have a current case where we're representing a child where the mom today wanted the adoption, 2 years later did not want it. And I know the problems that come with it. And I just want to also indicate, and again, it's not an easy thing, but there are provisions that allows you to say enough now. Like Section 35 allows the department to say it's enough now. We're going to terminate your rights so that the child can be available for adoption, because the child needs permanency. You cannot go and come back. I have a case currently where the child is 11. The mom left for 7 years, came back for 2 years, left for another 2 years. The child has been living with the couple for 12 years, and they want to now adopt the child because really they want to leave the country, and the husband is already working overseas, and the mom is refusing. How do you say somebody left the child for 7 years now, has no relationship with the child, must now, those are things that we need to unpack. We need to unpack those things, because if we're saying that we're saving the children's best interests, then that requires something deeper than just saying it's biological, it's biological. Yes, they could still remain in contact with them, they could, but we need to think about it. Let me just leave it at that. I wanted to quickly touch on the issue of rescission. So I thought we should maybe pause to talk about it in the light of the T versus T case from last year that you all might be familiar with. I mean, when we saw it, we all panicked, and you know, this is a mess that now the court is allowing the adoption to be rescinded after 7 years. I read the judgment again yesterday, and there are things in the judgment that worry me. One being the fact that the judges seem to think that the mom did not have any parental responsibilities and rights because the stepdad had adopted the child. I mean, I don't know how they got to that. There was a step-parent adoption. It didn't take away the rights of the adopted mom. But that's a lawyer thing, and I think I need to maybe write a case note on that to just, you know, it's caused a bit of confusion to me. So that is one thing that I think I have a problem with. On the bright side, you may see that the judgment has quite a lot on best interests. And I know it's still questionable maybe to some people whether what the court did was in the best interest of the children, but I think the facts of that case were so different that it won't be something that occur every day. So what I'm trying to say is we shouldn't panic that now there'll be a mass overnight trying to rescind adoptions. We must be, you know, we must guard against it. People should not be allowed to just rescind the adoptions as they please, because you have the situation in the US where, I don't know whether some of you saw 2 years ago, they placed a child back on a plane back to Russia that the couple had adopted, those kind of things. We don't want that. We should guard against it, but I think our law is clear that it won't be an easy thing for somebody to try and get an adoption rescinded outside of the parameters set by the law. I think that case was just a bit of its own kind of a dynamics kind of a thing. So just to say we shouldn't worry about it that much. And I want to share with you, I think this morning we talked a bit about issues of customary laws and stuff. There's a case called Manelli versus Manelli. I think it's 3-4 years old now, where the couple had adopted a child customarily. And when they divorced, the adoptive father tried to run away from responsibility, saying that there was never a proper adoption, they were never registered and all. And then the court smacked him in his face and said, it's not, it's going to happen. You did the rituals according to your culture, and the child is your child, and you adopted the child. What I thought about this, and even by the time when I read the judgment when it came out, was something that maybe should think about is as part of our amendments, providing for recognition of customary law adoptions. You know, that people have done, and if the law just recognizes them if they have been celebrated, you know, the way we do with customary marriages, if they've been celebrated in accordance with the practice of people, just an addition in the Children's Act saying that customary adoptions are recognized. They provide security for children, because this child involved in this case was about to start university, I think, was facing being rejected now by the adoptive father, who thought it would be easy to say, well, it was a customary adoption, now, you know, it's not really recognized by law. So let's think about that. I think it would be a nice addition to our law, and show that we actually celebrate diversity and acknowledge that South Africa is not just a homogeneous group. All right, my conclusion, and I think I'm right on time. Some of the points here have already been made by Dr. Mabi and Julia. Just to say that in my view, we have sound legal provisions that are aimed at ensuring that the best interests of a child are protected. Problem is the issue of implementation, misinterpretation of the law, majority of the time by the magistrates, and also, if somebody writes a manual or training book for the magistrate, they must remind them of best interests. When you're in the High Court and you're arguing best interests, you know. But I've tried to represent children in the magistrate court and struggled with, it's like there's no, you know, they forget. And I know I was sitting next to the ladies who were mentioning the issue of the rotation, they were whispering, they didn't know I heard them, the rotation of the presiding officers. That is causing a lot of problems in a lot of courts, a lot of delays in matters, and that's something that, again, I think the Department of Social Development, and I know they're trying, could engage with justice about potentially, not immediately, but in the future, having specialization and having magistrates to specialize. I know they don't like it for certain issues, but there are people, I think, who would be willing to just stay in their children's court and don't have to do criminal court and don't have to, you know, and could run it efficiently. Julia knows, other countries have children's court are run by judges who are specialist judges. We've met a lot of them, and the processes work far better than what we have now. So that's something we should consider. Again, I mentioned the presiding officers need training and how to really try and focus on the basics of a child. Not to say that they should not follow and tickle the legal requirements, but there's an emphasis that's needed in relation to best interest. Sometimes you cannot really believe that this is somebody who's supposed to read the law and really uphold the best interest of a child, things that are coming out of it. I like the clip from NACSA. I want to say that we need to do more, and I think the department needs to do more on adoption education in the country. I think I was keen seeing them know about all those people who climb on an aeroplane and pick up children somewhere and end up here with the children, and then they look at us, everybody with big eyes. They need to know that you can't do that. You cannot climb on an aeroplane and go pick up a child where we don't have an agreement with, where they don't recognize adoption, they even just have kafala or just guardianship. So we need to try and do that so that the department can also be covered when people try and claim that we didn't know. It's very important. Then you can say, but we have all these pamphlets, we have all these campaigns telling you that you cannot just go and pick up a child. And then, lastly, this is a very important point. I know it's a bit soppy. One of the things that's been worrying our office is that when we are requested to assist and give advice, there seems to be a decline in people caring and being compassionate for people, just generally. And more so in the issues of children. You know, you sit at the end of the day, you're like, but you know, the law is clear and they just don't seem to care. So you can't legislate care, but that's definitely something that we need to talk about. We need to really engage about. And when we're training younger people who are coming into the system, when we get opportunity to talk to magistrates, remind them to care. I know it's not going to be an easy thing, but in the space that we're in as a country, not even just as a sector, care, people need to be reminded to care. And I don't know, maybe we all need to start doing yoga or something. But we really, there's a lack of care, and that worries me because not everything can go to court. You can't solve everything by court orders, but people need to just be compassionate and use their brain and their skills to help you. Thank you. Excellent.